Welcome to this detailed discussion on marriage-based immigrant visa options for individuals facing removal proceedings after entering the United States without admission or parole. Hi, I'm Attorney Jay Francis. I'm a U.S. immigration lawyer based in Chicago, but serving all 50 states. If you or loved one is in this situation, understanding your option is critical. In this video, we will break down how you can pursue a green card through marriage to U.S. citizen, even while in removal proceedings. Number one, understanding the challenges of removal proceeding. Entering the U.S. without admission or parole creates unique challenges when seeking permanent residency. Unlike individuals who enter with a visa, parole, or ESTA, you may not qualify to adjust your status while in the U.S. In addition, removal proceedings can complicate the process further with strict timelines and legal requirements. However, the U.S. immigration law allows individuals in removal proceedings to pursue family-based immigration petitions, provided that they meet specific criteria. If you are married to a U.S. citizen, this relationship may form the foundation for lawful permanent residency application, even in complex cases. Number two, the importance of proving a bona fide marriage. The success of your case throughout the process relies on proving your marriage is genuine and not enter into for immigration benefits only. Here's the type of evidence that will help you to demonstrate that your marriage is a bona fide and real. Joint financial documents like bank account statements, shared rental agreements, or property ownership documents. Pictures documenting your relationship over time, not only you and your spouse, but with the families and friends, not just at home, but you took vacations together. Affidavits, or it's called letters, from families and friends affirming that they have a direct in-person knowledge of the relationship and they spend some time with you in person. Strong documentation is critical to overcoming scrutiny from USCIS, immigration court, and later with the consular post overseas. Absolutely critical to success of your case throughout the process. Don't forget. Number three, key steps to secure a marriage-based visa during removal proceedings. Filing Form I-130 is the first step. Your U.S. citizen spouse must file I-130, a petition for alien relative, with the USCIS to establish that your marriage is real, bona fide. This will be the first step that you're going to take. Approval of this petition is a critical first step as it confirms that your relationship qualify you for family-based immigration. But just be aware that this I-130 petition process will take quite some time, about 1 year or up to 18 months or more. So you need to be patient. Now, even though USCIS approves your I-130, you don't get any work permit. So just be aware. It's an important first step, but you don't get work permit when the USCIS approve your I-130 petition. The next step is usually a termination or admin closure of your removal proceeding. If you are in removal proceeding, you must work with immigration judge. Once your I-130 petition is approved, then you may request the court to terminate or admin close your removal proceeding. Because you will go through consular process, doesn't need to be complete dismissal. It can be admin closure. That would be sufficient for your case to proceed to next step. This step is absolutely necessary to proceed with the consular processing of your green card application later. When your removal proceeding is terminated or admin closed, then you may apply for I-601A waiver. Why? Because if you enter the U.S. without being inspected or admitted, you may need 601A provisional waiver of inadmissibility. This waiver is essential if your departure would cause extreme hardship to your U.S. citizen spouse. You will need to demonstrate hardships to your U.S. citizen spouse, such as financial strain, medical needs, or emotional distress. That would occur if you're removed. However, there are some exceptions to 601A waiver filing. For example, if you file I-589 asylum application within 6 months of your U.S. entry, the last one, most recent one, and avoided unauthorized employment in the U.S., you may skip 601A waiver process and move directly to consular interview stage. Once again, be aware that 601A waiver process takes quite some time, more than 2 years. Right now, it's between 2 and 3 years. And once again, even though USCIS may approve your 601A waiver case, you don't get work permit. So let's talk about the final step. Whether you go through waiver or not, your final destination is to attend consular interview. So in most cases, once your 601A waiver is approved, then you need to attend a visa interview at U.S. consulate in your home country in most cases. Proper preparation is critical at this stage to avoid triggering additional grounds of inadmissibility. Just remember, if you have any additional inadmissibility than unlawful presence, then you may be required to submit 601 waiver, which is different than 601A waiver. If you're required to submit 601 waiver, you may end up staying overseas very long time. So absolutely you need to be careful. Number 4, what are common challenges to this process and how to overcome them? Managing timelines in removal proceedings is absolutely important. Removal proceedings come with strict deadlines and procedural requirements. For example, you need to submit the motions, relief set by the due dates by the court, and if you miss your scheduled master calendar hearing, then the court will order you to be removed to the United States. So absolutely important. It is essential to align your immigration case with the court's timeline to avoid unnecessary delays or risk. Also, you need to know how the court governs each cases. And then that's why you need to work with experienced immigration attorney. Meeting the extreme hardship standard is also important. The extreme hardship requirement for 601A waiver is one of the most challenging aspects of the process. Providing detailed and persuasive documents is critical to meeting this standard. Examples include evidence of qualifying relatives, medical needs, financial dependencies, or emotional distress, medical conditions. Very important. Addressing unlawful presence or other bars to reentry is also important. Many individuals face barriers to adjustment due to unlawful presence or other inadmissibility factors. A thorough case evaluation by experienced immigration attorney will help identify and resolve these issues. Navigating marriage-based visa options during removal proceedings is a complex process that requires strategic legal guidance. You need to find immigration attorney specialized in these challenging cases, have successfully helped clients secure permanent residency despite significant legal obstacles. To sum it up, it's a challenging process, complex process, lengthy process, but at the end, there is a hope. You will get permanent residency if you navigate this process correctly with the help of experienced immigration attorney. Thank you so much for watching this video.